The broadcast is now starting. All attendees are in listen-only mode.
All right, everyone, and welcome to our latest edition of Work From Home Wednesday with Fastcase. Per usual, if you've done one of these before, my name is Ken. I am a West Coast-based reference attorney who is trying to teach people a new part of the law or a new legal skill in ideally the time it takes you to get a food delivery or 30 minutes or less. As usual, I add the caveat that this webinar is for information and educational purposes only. It is neither long enough nor meets the licensing requirements for you to receive CLE credit. But hopefully you'll get just as much value out of learning something specific. So what we're going to talk about today is going to be the sort of, I call it the subfield of law known as business interruption. Now, the interesting part about business interruption is that it is this really interesting sub-area of law that kind of merges contract law, principles of equity, but also constitutional law and constitutional provisions. So let's start with essentially the basics. So let's dive into sort of the history of business interruption law. Now, I will add that if you've been to these sessions before, you know that typically I use a lot of graphics, I hyperlink things. In this instance, I'm going to send to everyone a follow-up packet that's going to have a bunch of dockets. It's going to have a bunch of dockets of legislative text for proposed statutes. I'm also going to provide you with a nice, thick library of case law. So while my discussions are going to be more of a lecture style, you'll have plenty of reading to do after the session. Now, as always, you can send questions you may have after the session directly to support@fastcase.com. So now for the history. So business interruption law really started becoming valid in about 1840. So what was happening in 1840 was in Germany and in England, there was this sort of desire among what we would consider to be these socially responsible sort of financial backers, mostly dealing with those who were financially backing those providing freight services. So people were saying, okay, well, typically if I had a disruption with a delivery, the only thing that traditional financial backers, or what we would call old school insurers, would provide for insured parties would be the sort of traditional notion of they would restore the person back to where they were prior to the disruption. So they would give you the value of the cargo upon the freight. But more and more people were saying, okay, well, that's lovely, but what about my time? What is the value of my time? What is the value of my lost profits? What is the value of the sort of, or the financial value of the transition that I have to deal with? If I have a herd of livestock that ends up being, bogged down due to things like weather or the spread of disease, and I have to physically go out and acquire that herd and bring it. And it's actually funny because most of our earlier cases involved freight around livestock. So if I had to actually transport myself and go out, what sort of equity was available for me? Because I want a full restoration of sort of my financial placement prior to experiencing this disruption. Well, I have to say, between 1840 and 1903, this sort of endeavor completely failed. There is not a recorded case, and we have sort of less of an expanded repository available for this time period. But from all the cases on record between 1840 and 1903, there is not a single case where a person went out and tried to get financial gain or tried to have a claim be granted that did not concern the direct value of the cargo or the direct value of what we would today consider to be the sort of direct value of physical damage to our asset or to our business. So that really leads us to where we started to be in the early 1900s. Now, in the early 1900s, many of you may know, we started to deal in the United States with the prohibition of various types of liquors. So during that period, there was breweries and there were manufacturers of spirits that began to say, okay, well, I'm not gaining much traction by trying to make arguments under contract law. So I'm going to start making arguments via the Constitution. I'm going to look at things like the Contracts Clause, and I'm going to look at things such as the Takings Clause. Well, needless to say, and we'll talk about these sort of constitutional provisions in just a little bit, they were just as unsuccessful. So we sort of married around a little bit, and litigation around this issue became less and less prominent because people were just sick of trying to litigate something they were losing at. So between 1920 and 1940, we really didn't see much in terms of traction around litigation as it concerns business interruption. And then arrived what we now know as sort of state regulation, federal regulation of business interruption insurance. So that's really where we arrive in the sort of forefront around case law concerning business interruption. So while insurance policies for business interruption tend to vary from insurer to insurer, most operate in a similar fashion. They operate as an add-on or a rider to a property insurance policy, as physical property insurance often only covers physical damage to a business. Now, on the other hand, business interruption insurance says no physical damage is necessary and attempts to provide coverage for things like lost profits, fixed costs, and things like when a business stops running as a result of disruption via civil action. So most of our case law, and I will note that because our case law really started gaining traction in the mid-1900s, unfortunately, there's not a lot of case law around the issue. Doing a complete review of our entire nation, we really have about 75 to 100 actual published opinions that talk about business interruption as it concerns insurance claims. Now, the nice thing about having such a limited area is that we have the ability to really lawyer in ways that allow us to use sources that would typically be just considered persuasive. So that is why most of our case law really centers around a situation like our current one. It centers around business disruption or interruption as a result of a term of art that's oftentimes known as civil authority ingress or egress. Now, this is a legal phrase of art that is referenced in about 22 cases that are published about business interruption insurance. And what it essentially means, it is, let's use a scenario like the one we're currently in. COVID-19 is a pandemic. And let's say, for example, you own a restaurant. You have the governor of your state to issue an executive order saying that your restaurant cannot operate. Now, as such, you are losing revenue that you would otherwise have not for the executive order. Now, then you go to your insurer and you say, okay, well, I want to file a claim. I want to receive coverage via my business interruption policy. Now, if you follow the news, you know that what is also happening when people are filing these claims are insurance companies are saying, well, no, your business interruption policy is not covering issues around pandemics or things of that nature. Then, of course, you do what is happening in a lot of these cases, and you would go to court, and oftentimes you would seek relief via two types of relief when we're dealing with sort of denied claims. You would seek a declaratory judgment saying that your policy covers the current issues, so the current pandemic or the current loss of business. And you would also say, okay, well, this is a breach of contract because there is an intended coverage via the terms of this policy. There is very few cases on record where those two things do not go hand in hand. Now, as I was saying, okay, well, that's a sort of scenario around the issue. So let's talk about sort of other reasons why case law is not so expansive. Well, one reason that case law is not so readily available is because litigation is usually only necessary during times where civil authority via executive action forces a business closure. Now, throughout our sort of last 60 years, if you will, we've really only experienced this during two major events, Hurricane Katrina and our current pandemic. Now, and then of course, the other thing to remember is that insurers are for-profit businesses. So as a result, during times where claims are more frequent, they are more likely to deny claims. During times where business interruption is more, let's say, less of an issue, you have your insurers more likely to grant those claims or pay out those claims. So you're not seeing a person have to go to court and actually file litigation around the issue, because insurers are saying, okay, well, this year, you know, I had 5 insured parties that are seeking payout via business interruption policies. If you look at the sort of trend around sort of successful claims as it pertains to business interruption insurance, you notice that trend. You notice that in the off years, an insurance company is really only paying out less than 1% of insured parties. So you really have an effective rate of incidents around this coverage in less than 1%. Now, in times such as Hurricane Katrina or in issues around pandemics, that number can raise exponentially. You could be having an insurance company looking at, current estimates, $10 to $30 billion in settled claims a month. So those are the sort of practical considerations that we take in when we talk about the sort of trend in growing case law. Now, another thing to note is that when we're dealing with business interruption claims, more likely than not, they are often done as class actions. So if, for example, and I point this out because let's say that you are going out into the universe and you are wanting to do research around business interruption insurance and the sort of case law around the interpretation of your business interruption policy and the language within said policy. Oftentimes, I will actually add a keyword for class action because most of the time, business interruption cases are done as class actions. That is why when a person is doing research, they may often say, okay, well, I'm not finding anything. Well, in fact, what is happening is because they're often done as class actions, I was unable to find more than 9 to 10 active cases at a time throughout the last 60 years because of the fact that they're done as class actions. Now, it's also important to know that they're done as class actions because, as we'll discuss in just a moment, there are issues you should be aware of around class certification considerations and professional responsibility concerns for those who are licensed attorneys around solicitation. So, what are some takeaways from this very, very small universe of case law around business interruption insurance? Well, the first one is be prepared to argue the definition of physical loss. Now, it should be noted that in a number of business interruption policies, you have coverage for either physical damage, physical loss, or physical damage and physical loss. Now, for the layperson, they may think, okay, well, that kind of sounds like the same thing. But as those of you who know that there is oftentimes nothing within contracts that is sort of to be taken for granted. So there is a direct distinction within case law between what it means to cover business interruption for physical loss and what it means to cover business interruption for physical damage. So in many cases, for example, insurance companies have successfully agreed or argued, not agreed, well, they probably also agreed, they've successfully argued that a business interruption must be as only a direct result of physical damage to a business's real property or equipment. Now, what they have argued in these cases is they've argued that business interruption coverage is a supplement to funds received from direct physical damage and is not independent grounds for payout of insurance proceeds. Now, right away, many of you may be thinking that this would automatically exclude all insurance payouts for business interruptions caused by situations like COVID-19 pandemics, where physical damage is not seen with the human eye, or situations where business interruption is caused by the actions of a civil authority without actual physical harm to said business. Well, prior to 2008, you would have been correct. Then Hurricane Katrina happened, and we saw a growing sort of approval of judicial interpretation expanding what is covered by physical loss. And so this really began the start of the expansion of business interruption coverage by courts to events where no physical damage, and I emphasize no physical damage, occurred to a business, and particularly in cases where you have events involving civil authorities. As one court recently put it, business interruption coverage includes situations in which a covered peril does not cause any damage or loss to the insured's property, but instead causes a civil authority to issue an order prohibiting access to the insured property. As the court continues, a typical example is where a municipality issues an evacuation order in response to a hurricane. Remember, we're talking about Hurricane Katrina. The evacuation order will prohibit access to the insured's business and therefore cause a business interruption eligible for coverage, even though the hurricane itself caused no damage to the insured property. I will remind you, I will also send you out these cases for further exploration. So now for many, if you are already familiar with business interruption insurance policies, your next question may be whether or not this no physical damage interpretation extends beyond issues where the action of a civil authority results in a loss of revenue. The answer is yes. Post-2008, the answer is absolutely yes. This interpretation has been extended to situations such as where, let's say, a fire burned down one building in a business complex and other businesses not even touching the fire were still eligible for business interruption insurance payouts. Going even further, even when insurers have attempted to draft different coverage limits for civil authority business disruption versus direct physical damage business disruption, courts have also held that the higher direct physical damage limit applied even if no physical damage occurred to said business. As one of my favorite treatises on insurance, Couch on Insurance, likes to note, generally courts have found that a civil authority sublimit is inapplicable where losses are solely the result of a civil order, and further, and this is important to note, and further inapplicable where losses are caused by extraneous forces, which results in a business disruption. Now, a few things to take note of. When you are reviewing your personal business interruption policy or the business interruption policy of your client, the word, as I was talking about earlier, the word following physical does matter. If your policy only covers physical damage and does not cover physical loss, courts may not recognize the no physical damage interpretation. Now, if the policy does cover physical loss, but it also states direct physical loss, so if instead of saying the policy covers all physical loss, your policy instead says it covers direct physical loss, that is a distinction with an absolute difference, you need to be prepared to make an argument about proximate cause. The inclusion of the word direct is because the insurer is trying to include an argument that remote issues or remote causes for disruption are not eligible for coverage. For example, in the Hampton Foods versus Aetna insurance case, the Eighth Circuit held that a snowstorm, so remember we're talking about a snowstorm, followed by a civil condemnation order. Now note, in this case, the civil condemnation order was not actually due to the fact that this grocery store at issue actually experienced damage due to the snowstorm, but that the grocery store experienced just the threats of damage due to a snowstorm. The court agreed that the business interruption insurance does qualify or does give the grocery store grounds for payouts because the proximate cause of the, and this is important to note, the proximate cause of the business interruption and physical loss was the risk of damage to the property by the snowstorm and not the civil order itself. Now, this justification is further supported by other courts holding that such a definition of physical loss also should fit with the reasonable expectations of insurable risks by insurers. So keep that in mind when we're talking about proximate cause. Now, if you fall into the universe of people who have a policy that only covers physical damage, pandemics may still apply. Some considerations to think about is, does your policy have a communicable disease exclusion? And if it does have that exclusion, does it specifically include a virus? If you have a communicable disease exclusion that references a virus, there have been courts that note that you may lose on both the physical loss and physical damage exceptions. Another consideration, because this is often relevant, is what state or federal circuit are you in? If you are in the 2nd, 3rd, 7th, 8th, or 11th circuits, and their corresponding states, those states are more likely to include a communicable disease, and this is important to note, under the definition of not only physical loss, but also physical damage. Now, the reasoning in these circuits is that a communicable disease, such as our current pandemic, is spread through the air or via hand-to-mouth transmission only after contact with surfaces inside a building. As a result, physical damage is occurring because there is a business interruption due to a loss in revenue, as well as an increase in expenses necessary as a result of decontamination. Now, I'm focusing on the word, and I probably overemphasize the word decontamination, because if you are doing research around these various exceptions, I would also focus on not tailoring my research to pandemics specifically, but I would focus my research on case law around contaminants. So look at case law around issues such as the bird flu would be a prime example. Now, I will say that opponents of such an interpretation, as I just talked about, have successfully argued what I call the fear exception. Insurers have argued in certain courts, and luckily this is a growing minority of courts, they have argued that with or without a communicable disease exclusion, that the interruption of a business by the mere fear of contamination is not direct physical damage or direct physical loss. A prime example would be in Cleveland Simpson versus Fireman's Insurance Company. The court held that direct physical loss or damage coverage for business interruptions does not apply to business interruption or closure caused by a civil authority order that was put in place to not remedy damage that has already occurred, but put in place to prevent the further expansion of potential damage. The court says that this is because the civil order in this event was only put in place to prevent or reduce a peril. The court notes that a peril is an impending danger. So long as a danger remains a peril, no loss results. I do love their comparison. They say that one fond of intoxicating liquor may sit beside a barrel of whiskey for a day, but so long as no one smashes the bung, he will be as sober at the end of the day as when, with parched tongue, he began the ordeal of temptation. Peril is the fuse that leads to explosion, but if the fuse is never lit, no explosion follows, and thus the peril never achieves crystallization into damage or destruction. Now, with such eloquence, I want to agree. However, that is not the current trend. That was the viewpoint of the majority of cases in the 1950s and the 1960s. I always say that if you're dealing with an insurer who is arguing such a what I would consider to be the fear exception or the civil action as a result of peril, I would argue the mad cow disease exception. So this grew as a result. In 2006, beef companies began to seek coverage under business interruption policies due to trade embargoes. So essentially, in May of 2003, the U.S. closed off Canada. They said there was concern with beef brought into the country from Canada due to mad cow disease. Now, it should also be noted that during this time, the United States did not have proper testing in place in order to be able to confirm that beef was actually contaminated by mad cow disease. What was happening is from 2003 until proper testing somewhere around late 2006, early 2007, the United States simply as a policy treated beef coming in from Canada as being sort of de facto infected with mad cow disease. So this led in the case of Source Food versus United States Fidelity for the Eighth Circuit Court of Appeals to note that an interpretation of direct physical loss and damage was not whether, and this is important to note, not whether one could confirm the presence of communicable contaminants, but whether the relevant civil authority perceived the presence of said contaminants at the time the civil authority took action that resulted in an interruption of the business. That is often a critique of people seeking coverage during our current pandemic, is how does one confirm that a business is infected with the contaminants associated with COVID-19? So that is a great case for sort of addressing that issue. Now, sort of moving away from the idea of business interruption insurance case law, what are some other things that you could consider? And we're going to talk about constitutional provisions, but let's talk about sort of methods around things that do not situate in either constitutional relief or business interruption insurance litigation. So one thing you could do is you could consider engaging in the lobbying for statutory relief. Now, I know right away that seems like a lofty sort of ask for a person to engage within, but I point this out because there is currently growing sort of favorability for the idea of statutory relief. So right now we have 27 members of Congress and we have 5 states that have proposed some form of legislation that would retroactively make physical property insurance policies that include coverage for business interruption to forcibly include whether or not there was a communicable disease exclusion, whether or not they had the language of direct physical damage or physical loss, include claims based upon the COVID-19 pandemic within coverage within those policies. Now, of course, there is all sorts of insurance industry kickback. There is currently sort of feedback around well, will this bankrupt the insurance companies is one, critique we often hear. And they do that mostly because they say, okay, well, it's being applied retroactively and I'm going to be spending all this money, et cetera, et cetera. Now, the response to typical concerns around financial issues is it's fairly moot for the most part, because every version of the legislation that has been sort of provided, or every full text of the bills that are being thrown around in the following places: New Jersey, Massachusetts, Ohio, New York, and California, all include, and this is important to note, all include essentially repayment for insurance claims that are paid out that would not typically have been covered by those relevant policies, that are paid out as a direct result of the legislative mandate. So for most people, the argument around this will bankrupt the insurance industry could be potentially not a great one. Now, for all 5 of these bills that are currently in existence, the basic parameters are quite simple. You have to have a business that was eligible for the coverage. So they had a physical property insurance policy that included business interruption insurance, and that they were essentially a business with 150 employees or less. And that's really it. That is the bread and butter of the requirements. Every single one of them say that we will apply these statutes retroactively, but only until the point at which the COVID-19 sort of emergency pandemic provision ends. And that's really important to note, because the other arguments that you have people arguing against these sort of state legislative responses is, does such state action pass muster under the Contracts Clause? Now, if you know the Contracts Clause, you know that generally the Contracts Clause states that no state shall pass any law that impairs the obligation of private contracts. Now, it sounds pretty black and white when we talk about it directly, but we all know that this provision has never been as black and white or as draconian as it sounds when you just read the text of it. As the Supreme Court stated in W.B. Worthen, that literalism in the construction of the Contract Clause would make it destructive of the public interest by depriving the state of the prerogative of self-protection. So really the area where we see the Contract Clause least enforced is an area where we're currently sitting, where we have private contracts that are being potentially impaired by a statute where the state claims that the said statute is an exercise of police powers during emergency. Now, it should be noted that as it pertains to the Contracts Clause, a police power can be almost anything. Now, if you are Justice Holmes, he hated the Contracts Clause. He thought the Contracts Clause was completely redundant of other things such as due process protections, et cetera, et cetera. He said a police power can be anything that a state does to protect the lives, health, morals, comfort, and general welfare of the people. He believed that a state had almost unfettered discretion to modify private contracts, because he believed that private contracts are always designed with the expectation of present and future state regulation. In Hudson Water Company, which is kind of the most prevalent opinion, he noted that one whose rights, such as they are subject to state restriction, cannot remove them from the power of the state by making a contract about them. Now, that is why starting in 1934, and this is really important to note, the Supreme Court has never, and I do repeat, has never granted a contract clause challenge to a state statute, even if applied retroactively, if the statute met the following 3 requirements. Number 1, if the statute was passed during a state-recognized emergency. Number 2, if the state action at issue limited contractual impairment periods to the time of recognized emergency. And number 3, that the impairment period was for the general public and not a limited subset of the public. Now, you'll also hear Supreme Court cases talk about things such as, well, the state action of the state statute also needs to be reasonable, and it needs to be tailored to the emergency at issue. However, there is not, as we often run into when we're dealing with kind of these sort of fluffy standards of things like reasonableness, there is not a single Supreme Court case that even remotely considers overruling state action that meets the above three requirements I just noted on grounds that said state action was unreasonable or inappropriately tailored. So all in all, as state legislative actions play out, businesses with denied claims are left to the courts for relief. Now, it should be noted that we are currently in a period where class actions are growing. I'm going to send you out some great dockets so you yourself can continue tracking the progress of these class actions, because they're going to really start engaging, at least based upon the complaints, they're really going to start engaging on novel areas around things like insurance coverage, but also novel areas around when a business interruption via executive order can result in a violation of your constitutional rights. So before I move into constitutional provisions, allow me to talk briefly about congressional responses. So Congress has also done a limited amount about sort of in reaction to business interruption. So what we know so far is that on March 18th, we had 24 members of Congress reach out to various interest groups for insurance policies, asking those interest groups to provide coverage under those relevant policies for business interruption, whether or not they would typically exclude those coverage based upon a pandemic. Now, as you probably guessed, that same day, those same insurance groups essentially told those members of Congress to kick proverbial rocks. They write that, in their response letter, they write that while they will, and this kind of makes me giggle just a little bit, they write that while they will not pay out COVID-19 business interruption claims, because, and I quote, business interruption policies do not provide coverage against communicable diseases such as COVID-19, that those same insurers will work with the insured on things like flexibility in the payment of their premiums. Now, on March 26th, that same group of insurers then reached out to Congress directly, and they proposed the following solution. They proposed a solution where they would allow insured businesses to file COVID-19 business interruption claims, and they would grant those claims, but only if Congress provided federal funds for the payouts. So then following that request, the Congressional Research Service unfortunately released what is one of their worst research reports to date, which was a 3-page report entitled Business Interruption Insurance and COVID-19. And while it does discuss case law to a light amount, it provides no case law references, and it actually, for whatever weird reason, linked to blog posts instead of linking to actual cases. And the majority of the blog posts were covered by paywalls, meaning that you couldn't actually read the blog without paying a subscription to the host of the blog itself. It was an interesting report and kind of an anomaly given the sort of meat around these reports that we get from the Congressional Research Service. And then finally, the most relevant action is on April 14th. We did have 10 members of Congress, 9 Democrats, 1 Republican, introduced H.R. 6494 into the House. Now, this bill proposed to force insurers to pay out business interruption claims related to COVID-19, similar in versions to the state legislation proposed. Now, what is important to note is that despite the insurer's optimism, this bill does not include federal funds to assist in business interruption claim payouts. Now, the last area that we're going to talk about is going to be the idea of what sort of constitutional protections are in place for business interruption. Now, we all know that anytime we're talking about constitutional law, even in the world of business interruption, it is an uphill battle, always. So I will point out right away that there is at least one business in Pennsylvania that has launched a 41-page complaint that is laying out a constitutional violation via COVID-19 based upon the Pennsylvania's executive order forcing his business to close as a result of it being non-essential. Now, I will say that his grounds, while legally questionable, actually do have some precedent, believe it or not. So starting in 1887, in the case of Mugler v. Kansas, people have argued primarily before the Supreme Court that the takings clause, which generally states that private property taken by the state for public use requires just compensation to the owner of the private property. Those same people argued that state overregulation that removes economic usability of a private business should be recognized as a taking requiring compensation. Now, I will also say that starting with Mugler in 1887, the Supreme Court also began rejecting just as quickly the argument that state overregulation means invalid taking requiring compensation. In Mugler, for example, an outright prohibition on alcohol did not constitute a taking for a brewery. The court ultimately said that the fact that the brewery still owned the physical real property that could be used for other purposes was enough to say that the business had not suffered an unconstitutional taking. Now, since Mugler, we have had plenty of arguments around the idea of a regulatory taking. Unfortunately, in those cases, the success rates have not been much higher. Now, I will say that Supreme Court jurisprudence does appear to recognize regulatory takings when a business owner can show that business regulation has deprived an owner of all economically beneficial use, even for a temporary period of time for a business. So the one Supreme Court case that gives me hope on this ground is going to be your First Lutheran Church versus Los Angeles County. Now, in this case, there was a flood, and it destroyed this church. Now, what happened in this case was that there was then a California ordinance that said, okay, well, sorry, church, you're not able to actually rebuild your church at this time. So the court ultimately held that that period of time that the church was not allowed to rebuild was, for all intents and purposes, an unconstitutional taking because of the fact that that business lost all usage of that property. So if we consider this to be analogous to our current issue, we can think of how if an executive order has removed all use of your business because it is virtually against state law or state policy to use your business at all as it is not essential, that could be grounds for meeting the arguments based upon First Lutheran Church. Now, I will say that absent such extremes, courts have held that a prohibition on business use is not a taking if you still, as I noted before, if you still own the real estate, if you have things like a situation where a required killing of cattle due to the fear of the spread of disease, that would also not be a taking of your business. There's even been a case law where a regulation that diminishes the value of your business or property by 90 to 95% is not recognized as a regulatory taking. So just some things to keep in mind around our various constitutional provisions. I will also say that the person in this case also made an argument around due process. I would encourage you to check it out. I'm not as confident in that because it's mostly rooted around the fact that the process for which a business could be recognized as non-essential didn't have things like deadlines, and that the stay-at-home order itself did not have a defined ending, et cetera, et cetera. But based upon my review of case law, that has not really been something that an executive action not having a defined ending date has not typically been recognized as a violation of due process. But maybe there are some keen legal researchers out there that can locate a case that proves me wrong on this matter. So definitely check out that full complaint when you receive it. Now, one last thing is some considerations to take into account when you are reviewing the dockets around current litigation. Some considerations to note are: expect to say goodbye to communicable disease exclusions. More and more states are noting, because most states do approve the various documents used to provide insurance policies. Most states, as public pressure is growing, most states have noted that they will likely in the next round of approved documents no longer allow insurers to provide an exclusion based upon this, or at least an exclusion for communicable diseases based specifically on viruses. And for all practical purposes, if you look at the limited case law around the issues of communicable diseases, most courts have said that those provisions are ambiguous. And when we have an ambiguous provision, most courts also say that we interpret that ambiguous provision in favor of the insured party and not the insurer. Another thing to note is I would also expect battles over class actions as it concerns notice and solicitation. So in the world of social media, more and more people now are trying to provide notice to potential class members via web pages and things like Facebook. I have seen a growing sort of repository of cases where individuals and courts consistently remind people that notice under Rule 23 of the Federal Rules of Civil Procedure is for the protection of members of the class and not for sort of personal gratifying solicitation of business. Now, the third consideration that is growing but is also important to note is that in this sort of area concerning contamination, that physical damage and loss can include products, so things such as livestock, whether that contaminated product, such as livestock, is on or off site. So during the bird flu, we had a case called Rembrandt versus Illinois Union Insurance, and also the Source Food versus U.S. Fidelity, the second opinion on this, that held that a contaminated asset need not be at the business's physical location in order for BI coverage to apply. Now, the caveat about this is to note is that in the event where you have something like contaminated livestock that is property of the business that is located off-site, the courts have only held that BI insurance policy coverage applied in the event where the language in the policy covered all direct physical loss or all direct physical coverage and does not apply to insurance provisions for BI that use the term direct property damage or loss to property. Now, coverage would apply if they use the language of direct property damage or loss of property. So once more, it's important to note the difference between to and of, and between whether your policy is an all-risk policy or a direct damage to policy. So keep those caveats in mind. And then the last and not least thing I promised that I'll talk about before I let you go is that estoppel arguments are never working. So oftentimes we have less experienced legal practitioners. We have our sort of self-representing individuals who go before courts and try to argue that the mere receipt by an insurance company of your premium payments gives that insured party coverage of events that are not otherwise laid out within the provisions of that insurance policy. I like to refer to this as what we call the sort of sick bull doctrine. So the sick bull doctrine used to say that, let's say that in somewhere around the 1950s or 1960s, you had an insurance policy that was designed to cover a bull or livestock. The policy would list things like the livestock or the bull at issue must be in healthy condition. However, you meet with your insurance company or a representative of your insurance company. That representative of the insurance company knows that while the insurance policy says only healthy bulls can be covered, that your bull at issue is actually quite sick. So the knowledge of a issue around for which the text of the policy would not typically apply in the 1950s, 1960s, and even part of the 1970s would have said, okay, well, based upon, sort of equity provisions and estoppel and waiver, that the knowledge of the sort of additional covered events that is contrary to the policy would make the insurance company have to pay out. That is no longer the current trend. Now the current trend essentially says that, as one court notes, that while an insurer may be stopped by its conduct or its knowledge from insisting upon a forfeiture of a policy, the coverage or restrictions on the coverage cannot be extended by the doctrine of waiver or estoppel. To continue on, the doctrine of waiver or estoppel cannot be invoked to create a primary liability and bring it within the coverage of the policy, risks not included or contemplated by its terms. So just another thing to keep in mind. All right, everyone. We are well over, and I appreciate everyone for sticking with me. I hope you found this useful. A couple of things to expect. You should be receiving an email from me in the next 2 to 3 business days that's going to contain things like dockets that I've referenced in this session. I'm going to include for you a number of class action dockets. There have been, since March 24th, 6 or 7 class actions filed. I'm going to send you the docket sheets and the complaints for those cases. I'm also going to send you any of the relevant opinions that I've talked about, Supreme Court, the various Court of Appeals decisions, and relevant state law cases. So for those of you who need some additional reading on this matter, make sure you check those out. As always, you can feel free to reach out to me directly, either support@fastcase.com or casestrickland@fastcase.com. And then, of course, there's just a cute picture of myself and my niece because we are so happy to do these things. And I will note we did take this picture prior to social distancing being the norm. All in all, have a great rest of your week, and thank you for coming out to the latest edition of Work From Home Wednesday with Fastcase. Thanks so much.